SJC-12330, Commonwealth v. Joseph Fragata.
Good morning, Mr. DeMayo.
Good morning. May it please the court. Christopher DeMayo for Joseph Fragata. Mr. Fragata was charged with 5 different crimes relating to an argument with his then girlfriend, Gloria Farias, on Christmas of 2015. He was acquitted of the 4 most serious charges: strangulation, kidnapping, assault and battery with a deadly weapon, assault on a family member. He was just convicted of intimidation. The basis for the intimidation charge is slight. It's just a couple of pages in the transcript, around pages 98 and 99. In the light most favorable to the Commonwealth, that evidence shows that after the company had left Christmas supper, Mr. Fragata started yelling at Ms. Farias and calling her names. She testified this hurt her feelings. She started crying. She threatened to call 911. At that point, she testified Mr. Fragata took her phone, and that is the word she used, took. So it's not clear from the way the evidence came in whether he grabbed it from her hand or whether it was sitting out and he snatched it off a table. In any event, the prosecutor here was clear. The basis for the intimidation count was this act of taking the phone after the indication.
Well, is that clear? Because you're both arguing whether or not there was an assault. And your position is there was never an assault before the phone was taken.
True.
And the Commonwealth's position seems to be assault of conduct. So what about this? After he takes the phone, she goes and she sits on the couch. And then she's upset. She wants to leave. He physically will not let her leave. She asks for the phone back, and the phone doesn't come back. Under those facts, why isn't there an assault?
Why isn't there an assault?
Why is there not an assault on in that sequence?
The first answer is that's not the way it came into the. When you read Judge Nadeau's charge, he's talking about taking the phone. The second answer is yes. If we might have a different case if the jury had not acquitted him of kidnapping, but they didn't buy the argument that he wasn't letting her leave the room and that it was an ongoing kidnapping.
But why isn't taking the phone an assault in some way?
Well, taking the phone could be an assault, but the question, what we're arguing is there needs to be a predicate crime at the time of the intimidating act. I think what you're saying, Justice Cipher, is that it's both the predicate crime and the intimidation,
right.
And we don't think that's the law. And we don't think it's an assault here just because of the way it came in. It could, certainly to be clear, you could have. I think just because of the way this was presented by the government, it was the government's burden to develop the record. We don't really have intimidation. I don't know that it would be intimidating at all if she said, "I'm calling 911," and he picked it up. Certainly, if it had come in and he said, like, he had stormed across the room and done something assaultive so that a reasonable person would apprehend a battery, that would be an assault. And certainly, if he had, like, wrenched it from her hand.
Well, don't we have to consider the facts in context with the vile name calling and her being upset in the fight?
You do, but I would suggest that even under Lattimore is not really a warrant to speculate on what happened. And this is already in the light most favorable to the Commonwealth. If you read pages 98 and 99, which she originally says that he had the phone when the prosecutor asks, where were you? He's asking about where everyone was when she threatened to call 911, and she says the phone was in his hand. And then there's further questions, which I would have objected, asked, and answered, and then it later came out, well, he took it from my. So it's already in the light most favorable that he took it from her in some manner. I don't think you can go any further, even under Lattimore, to infer that there was an assault, to infer anything about it. It would have been a simple matter for the prosecution to develop this more if there had, in fact, been an actual assault if there had been.
Along those lines, I imagine you would have a different position if the judge had instructed the jury that they had to find that there was some crime that had occurred, and that it was an assault after she went to the couch, tried to leave, and tried to get the phone back. If that had been the charge to the jury, would you have a different position?
Yeah, that would be a different case, I think.
Okay,
That would be a
all
different case.
So if I can be
The way
quick-
this came in, it came in very quickly. Like I said, it's just a couple of pages because it was moving on to the other 4 charges, which were the big charges of kidnapping and so forth that the prosecutor moved into. So as a result, there's not a whole lot here.
Now,
So-
am I correct? I know there's discussion about C2, but best I can tell, page 156 of the transcript, the judge only instructed as to C1, as to whether or not she was a witness or potential witness at any stage of the criminal investigation or other criminal proceeding.
Yes, well, I think that was probably an error. I didn't realize that until later, because it's for reasons that we put in the brief, and this is the sort of point of contention with me and my brother. C1 seems to be talking about a violation, or C1 is talking about any stage of a criminal investigation, and then there's the argument. So my argument was, how could there be a criminal investigation? She didn't call the police for another hour. How could there? And there's the argument in the red brief that there's this reporting. There's sort of like an inchoate reporting stage of an investigation before the police actually know what's going on. To me, that's sort of a strained argument. And it would also, if you read one that broadly, for reasons we put in the reply brief, it wouldn't. There'd be no need for little Roman II. So it seems to me we would have to be in Little Roman II, where it's a witness providing, it's a witness, or not a witness, but someone who has records, documents, or information that relate to violation of a criminal statute.
But you say, but the jury wasn't instructed as to that.
Yes.
The jury was instructed only as to one. So doesn't this conviction rise or fall as to whether it fits one, because the jury wasn't given two?
Well, if it's one, then I submit that we just win on the facts that there was no criminal investigation. So
I mean,
I'm kind of giving the government.
Affirm, let's assume that, let's imagine that we say, well, it doesn't fit C1, but it would fit C2, but where the jury was not instructed as to C2 and therefore made no finding as to C2, how can we affirm a conviction on a basis that the jury was never given?
I agree. I mean, it seems to me if this is under C2, which then it fails for the reason I state, and if it's under C1, it fails for the reason that there wasn't a criminal investigation, unless you buy the government's theory that there was this inchoate investigation that the police didn't know about, but they were investigating.
You argue that a telephone call to the police commences the investigation, right?
I would argue, yes, exactly.
So anything before that is not going to be intimidation of a witness.
Yes.
Okay, so a witness to a shooting puts a cell phone up to his ear. The shooter goes up to the person, points the gun at him, and says, "Call the police and you're dead." Is that intimidation of a witness?
Well, that would be under 1, wouldn't it? That would be somebody who has information pertaining to the shooting as a violent crime. It's a criminal statute that was violated.
That's C2.
So, yeah, sorry, C2. I'm getting them mixed up. So either way, it would be, so that would be covered.
I'm just trying to tease
Yes.
out what you mean by
Yes.
what commences an investigation.
Yes.
So people have information about a crime.
People who have information on crime, that's the way the statute has always been. Even in the older cases, both sides cite Belle Isle, which is a 20-year-old case.
No, I mean, I get your argument that
Yeah.
there needs to be a crime in
Right.
order for there to be intimidation of a witness, because if there's no crime, then there's no intimidation.
And, yeah, so I take your point, Chief Justice Ganson. It probably should have been something I would have focused in on more, but I guess I'm giving the government the benefit, and if I think Section 1 cannot work as a matter of law for the reasons I've just stated, and Section 2 can't work on these particular facts because of the way it came in.
And we're going to Justice Gaziano's example. you're instructing a jury, let's imagine the jury was instructed as to C2. Would the jury have to find that there indeed was a crime, or simply that, how would you instruct a jury?
So the rule that we have proposed is that if the court can say as a matter of law, there's no predicate crime, if he would have to grant a required finding of not guilty for the underlying predicate crime, then the intimidation count is derivative and it should go with it. But if there's a jury question, they should both go to the jury.
Okay, and let's assume that there is a jury question as to whether or not a crime was committed before the phone call was made. What do you tell a jury? They would not need to find beyond a reasonable doubt that there was a crime, or would they? I'm just trying to, I don't know the answer.
It's confusing because normally in these cases, they're both tried together. Here they didn't, I mean, it's sort of telling, they didn't charge Mr. Fragata with assault or with doing anything before he did the intimidating act. So normally it would be clear for the jury because they would have both of these things in their mind. It is difficult. I guess you would have to have the prosecutor say what the predicate crime is, and allude to it in the jury instruction on intimidation. Do you find that the defendant was attempting to, suppress information about this alleged crime of assault or arson or whatever it may be? It's difficult because they didn't charge Mr. Fragata with any of those things.
Putting aside that your position that C1 would become superfluous with their definition of C2, just put that aside for a moment.
Okay.
Are you saying when it comes to C1 and C2 that for them to apply, there has to be some sort of criminal conduct before the intimidation under both subsections?
No, I'm not. Well,
let me make it easier. What has to be shown
for
has
C1,
occurred for C2?
For C1, there has to be an investigation. So I assume there would, in most times, there wouldn't be an investigation unless there was some basis or at least a potential crime.
Right.
For the language in 2, aware of information, records, documents, or objects that relate to a violation of a criminal statute. Literally, that requires a crime, but what I've just suggested to Justice Gantz is you need at least a potential crime, and if the court can say, as a matter of law, no yelling and swearing is not assault, there's no crime. If you can say, as a matter of law, there's no crime on that predicate crime, then there can't be an intimidation. The intimidation count is derivative. So if this court or the trial court can say, as a matter of law, whatever the prosecution is alleging the defendant did, or whatever the crime is he wanted to suppress evidence of, he didn't want to get to the police, if you can say, no, that there's no possible way that could be a crime. Yelling at people, swearing at people isn't a crime. Then I'm suggesting there's a required finding on the underlying crime and the intimidation count, which is derivative of it. So I'm not saying there needs to be an actual crime. I'm saying there has to be at least a possible colorable crime that could get to the jury. And that's why I answered Justice Gantz's question that they would both go to the jury together or they would both be dismissed together.
So if you're right on, this is why I asked the question, if you're right on C1 and the jury wasn't charged on C2, do we look at whether or not there would have been enough evidence on whether or not the case can be retried or whether or not there was an insufficiency of the evidence as it relates to C2?
I'm sorry, could you
Do you
say?
understand the question? So let's say that you're right on C1,
Okay,
but the jury was never charged on C2.
okay.
What happens if the evidence would have been sufficient on C2?
If the evidence would have been sufficient, if you find that it could have been, then I guess you would have to remand it.
That's my question.
Yes, but Mr. Fragata is requesting that, looking at this record, the court makes a finding that this was insufficient, just based on really the 2 pages of transcript.
Right, but my point is we have to analyze C2 either way.
Yes, yes. If I have a moment, I don't know if the court is going to reach the evidentiary issue, but I just wanted to say a word about the letter and drawings that came in. These,
Wouldn't that be a discretionary call with the judge? I mean,
It is, it's an abuse of discretion, but
here we have, you know, there's an allegation of strangulation, and then he's in jail, and he sends her letters with these gruesome depictions of someone being strangled. It's kind of a, hey, you better not testify.
Well, that is the argument, Justice Gaziano, that they made. I would submit that that's kind of, when you read the whole thing, when you read the letter and look at all, that's one of the drawings. There's a whole series of drawings. They're obviously prejudicial. They're just sort of vulgar and important. They're not the kind of things that would reflect well on Mr. Fragata in the jury room. So when you take the possibility, that was the argument, it's some kind of consciousness of guilt or some kind of confession. I would submit
That was the jury instruction, and that's what the Commonwealth argued, right?
Right, and I would submit that it's so, those pictures really just show animosity, because he was in jail,
Yeah.
but they don't, they do not, I would submit it's speculative.
But in the domestic violence context, when you say that send someone a depiction of them being strangled to death is probably a little bit intimidating.
I would submit that in this case, it was not, when you take the probative value, the only way it's really probative is if you say the kind of guy who draws these pictures and sends them is the kind of guy who beats up his girlfriend. In other words,
or the kind of guy that doesn't want his girlfriend to testify against him.
Well, I don't see that he wrote a letter, it doesn't say anything. I think that's too far, I won't say it's far-fetched, but it's too speculative to give to the jury when you have to weigh it against.
I think it meant.
I'm sorry?
What did it mean?
What did those drawings
the
mean?
drawing
There's a
mean?
bunch of weird drawings. I don't know what they meant.
What did it mean, the one we're talking about, though, being strangled? What did that mean when he sent that to her? What was the intent of that?
I think the intent of that one, like all the others, was just to show that he was mad at her. The letter begins, like your portrait. So I don't know. There's a lot of talk in the transcript about Metallica and death metal, and are you familiar with these pictures? And I don't know. I'm not really in a position to say what he meant, but I would just submit that the only possible.
Well, could the jury draw inferences about what he meant based on their common experience and looking at the drawings?
Well, again, this is like Justice Gaziano's question, and could you infer that this was an attempt to intimidate, to silence her? You could. I'm not saying you couldn't. I'm just saying it's speculative. That one picture, when you look, there's a bunch of pictures, right? And when you weigh that against the fact that it's a bad act, it's a subsequent bad act, but not a prior bad act. But
if it's a subsequent bad act, isn't that what you're arguing it should be in order to meet the intimidation charge? It would have to be a subsequent bad act, wouldn't it?
Yeah, but he wasn't charged with it. And that's the other issue. It's kind of confusing because they kept referring to that as intimidating, but he was charged with intimidation for the Christmas Day act of taking the phone. So it's not only kind of inflammatory and prejudicial, it's also confusing. And the jury sent a question about the elements of intimidation, and that was the only count he was convicted of, so that kind of
Was there anything wrong with the judge's instructions or answer to the question?
The judge, no. The judge's instructions, he did instruct the jury that this picture is not part of the intimidation count, although he did it, he waited.
Right, but no,
he
I'm
waited a
asking
day.
when the jury asked a question about that charge and the judge answered the question, was there an error in the charge?
We have not raised any error in that answer.
Well, he did say those photographs, they don't relate to this count, which is count 2 with respect to an alleged intimidation. Again, you decide this complaint, this count, rather of intimidation of a witness based upon the general contention of the Commonwealth that Mr. Fragata prevented Mrs. Farias from seeking assistance and took her cell phone from her and whatever else she would find. Again, that's all for you to decide one way or the other. So he specifically said
it was clear.
photographs.
I said that. He should have said it, I think, when the pictures came in the day before. But our main argument isn't so much confusion. It's just that it's inflammatory. It has very little probative value, I would submit. Even if it, you would have to give it to the jury and then ask them to make this inference about this death metal picture of a snake around a woman, and for he must have meant don't testify. That's not very strong evidence, I would say, when you weigh it against the possible prejudice. But so we would ask that if you don't find for Mr. Fragata on point of error one, that you find this was an abuse of discretion and give him a new trial. Thank you.
All right, thank you.
Good morning, Chief Justice, members of the court. Roger Michael,
Before you get started,
Commonwealth. Yes, sir.
you cited Commonwealth versus Fletcher. You made no reference that it was a 128 until I looked at the case and discovered it was a 128.
We attached it as a 128, Your Honor.
It's on the brief. The brief doesn't make reference to it as a 128.
I apologize for that.
All right, I mean,
Uh,
you should, having served in the appeals court for many years, you should recognize that the distinction matters to us. It's not an appeals court decision, it's a decision of a panel of the appeals court. Okay,
Actually, Your Honor, my brothers just pointed out that in footnote 2 of my brief, I indicated specifically that the decision was issued pursuant to Rule 128.
all right, I'm sorry. I must have missed that.
I thought that I had.
You owe him one.
All right, well, may it please the court. Roger Michael for the Commonwealth. I just wanted to start in by clarifying the judge's charge. I think that's the skeleton key to a lot of this. And there was a bit of, I think, inadvertent imprecision about the presentation of that. The judge charged the defendant, in order to prove the defendant guilty of intimidation, they must establish beyond a reasonable doubt the following three things. First, that the defendant directly or indirectly attempted to cause physical injury or intimidated Ms. Farias. Second, that Ms. Farias was a witness or potential witness in any stage of a criminal investigation or criminal proceeding. And third, that the defendant did so willfully with a specific intent to impede, obstruct, delay, or otherwise interfere with a criminal investigation. I absolutely agree with the panel. There's no question this case proceeds under clause Roman numeral lowercase 1. And if it will rise or fall, as you say, on whether or not the...
Didn't you have a better intimidation charge on the letters than you did on what you actually charged?
Pardon me, Your Honor?
Don't you have a better intimidation case on the letters that was a bad act issue as opposed to...
Unfortunately, Your Honor, I was not present during the original trial. I might have tried the case differently myself. I agree absolutely that the letter was an intimidating document and could only have been read that way, as Justice Cipher said, I think, by the defendant
But
here.
probably stronger evidence than the snatch on the cell phone, right?
Well, yes and no. I mean, that episode was conjoined with a very violent episode, as described at least by Ms. Farias in the record of the case.
Right,
So there's no question that was part and parcel of a
But
bigger picture.
you don't use
involved.
that either. I mean, Justice Lowy begins by pointing out you had a pretty straightforward intimidation case, except for you've got the timing all backwards.
Would that I could go back in time, Your Honor, but the reality is that the intimidation that was present, I think, with respect to the incident that was charged, i.e. the seizure of the telephone, the holding her hostage for 45 minutes.
But as it was tried, we have to look at what preceded the seizing of the cell phone, not what happened after that.
I disagree with that, Your Honor, and I know my brother presented it that way. If you look at the testimony of the victim here, and it spans about 2.5 pages, as my brother said, from 99 to about 101 or 102, what she describes is that initial episode involving the yelling and screaming and the seizure of the phone. But then she goes on to describe a lengthy period, about 45 minutes, where he prevents her from leaving the apartment, lays his hands on her. He says, I went several times. She goes to the door to try to leave, specifically, she says, in order to place the 911 call. And as soon as I would go near the door, he was back and then she gets interrupted. And the purpose of you running to the door, I was trying to get out and trying to call 911 for my safety. Okay, and when you ran to the door to call 911, what did the defendant do? He was standing in the way, grabbing me by the arms. Okay.
I get that, but that's not how you presented the case, not you, but how your office presented the case, right? I'm just reading the prosecution's summary. She indicated that she felt sad. She felt sad that Mr. Fragata would use that language. He called her a blank. 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 He used that language. He was yelling. He was screaming. He was using loud tones and yelling at her. And what did she do in response to that? Well, she wanted to call 911. That's the basis. Isn't that?
Well, the arguments are not evidence, Your Honor.
No, I understand it, but isn't the way the whole case was, the whole intimidation case tried based on the fact that the screaming was the underlying crime.
I don't think so. I mean, I think if you read even that brief argument section that you read, he talks about the general intimidation that prevented her from making the call. There's no question that the evidence at trial described exactly what I just read to you, which is a lengthy period, 45 minutes, of her using a combination of physical intimidation and actual assaultive behavior.
The closing. She took her phone out and attempted to call 911, at which point Joseph Fragata grabbed her phone from her, prevented her from calling 911. That's intimidation of a witness. I mean, we really do look at all the other stuff then?
Well, all of this evidence, Your Honor, and the witness went on to describe a lengthy period of assaultive conduct, of batteries, of confinement, all of which relates to the question of intimidation. I mean, in this context, the case law is pretty clear. Intimidation requires, quote, putting a person in fear for the purpose of influencing his or her conduct.
I get the law and I get the facts, but was the jury instructed by anyone that it wasn't just the phone call after the name calling that's the intimidation claim? And if so, where in the record? Because that would be very important to me, at least.
The judge charged the defendant directly or indirectly attempted to cause physical injury to the victim, caused physical injury to her, or intimidated Ms. Farias.
But isn't that in his supplemental charge?
He charged the same way both times.
On page 176, he says that Mr. Fragata allegedly prevented Ms. Farias from leaving and/or taking her cell phone, those kinds of things.
And then at 155 and 156, there's a second charge, the initial charge, which describes more or less the same kind of approach. But I agree, absolutely.
So the government argued it narrowly, but Judge Nadeau broadly defined it.
Absolutely. I mean, the argument is not evidence in the case. I don't think it's by any means the alpha and omega of how the jury is meant to consider the case. The jury is meant to apply the law as described by the judge in his charge. As you point out, it was much more comprehensive than simply grabbing the telephone. And the statute itself contemplates conduct much more broadly than the kind of conduct that was described.
But you have the judge's instructions. Well, let me step back. What is the stage of the criminal investigation or other criminal proceeding which you contend existed at the time of the
So that, I think, is
taking
actually the
of the
most
cell
interesting
phone?
feature of this case. Because I think the trajectory of the statute, as you know, it's been amended a couple of times back in the late 90s and again in the early 2000s. The trajectory has been to make the statute ever more broad, ever more forward-looking, and to capture wider and wider range of conduct. My brother has interpreted this portion of C1 at any stage of a criminal proceeding to modify the language in C itself, rather than modifying, as is grammatically required, the language of subsection 1, in which it is found. So the idea here is that subsection 1, 2, 3, 4, and 5 all describe people whom are covered by the statute. And the first category of folks is witnesses or potential witnesses, and I flag potential witness because it already injects into this analysis a kind of foreseeability or forward-looking quality to the statute, because potential witness doesn't mean a witness in something that already exists. It's a person who may at some time become a witness, that it's reasonably foreseeable that such a person will become a witness. But then there's no comma. It says at any stage of a criminal investigation. So that means this person is reasonably foreseeably a witness at any stage in a criminal proceeding, i.e., this person may or may not become a witness, i.e., it's reasonably foreseeable that this person may or may not become a witness at a criminal proceeding. And that's how that should be read, because then it goes on to describe 4 other categories of people, and none of the language in any of those sections has ever been read to modify the intimidates, harasses, or misleads section, i.e. specifying a temporal limitation on when that has to occur. It's a descriptor of the kind of person who is covered, a person who is reasonably foreseeably a witness in a criminal proceeding of some kind. There is no question in this case that we're dealing with such a person. So that, I suggest to you, is the only way to read the statute, the best way to read the statute. Not only does it comport with the plain language of the statute, but it also comports with all of the case law which has looked at what the legislature was trying to do through the various emendations and amendments to the statute. So there's a quote from McCreary: "The history indicates the legislature intended the statute as amended to include furnishing information to a police officer at any stage of a criminal investigation." And I would put it to you that this language in C1 describes not the Again, not the temporal dimension in which C applies, but the kind of person who's meant to be covered by the statute. And so C1 was absolutely the correct choice for the judge to apply to this case. It's the one that he did apply, and the facts of the case fall squarely under C1.
I guess if we could please go back to the line of questions so that Justice Kafka was asking.
Sure.
Because it seems to me that after she goes to the couch,
Yep.
there is assaultive behavior, and she wants that phone back, and that, in light most favorable to the Commonwealth, would satisfy C1. But the point I think Justice Kafka was asking about is the case wasn't tried that way. The judge didn't specify whether or not that was the predicate. And I'm sort of asking you in general, what do we do with that as we're reviewing this?
Well, I have to say, I respectfully disagree when you say the case wasn't tried that way. There was a very brief argument by both defense counsel and prosecutor here. They highlighted some features of their case. For us to say that that is the sum total of the evidence that we should consider on appeal on a question of legal sufficiency, it's just not right. I mean, first of all, the arguments themselves, as we know, as a matter of law, are not even evidence in the case in the first place. What governs how this case was charged, the evidence that's relevant to the disposition, is the judge's charge.
But there's no issue, at least as I see it right this moment, of legal sufficiency under subsection 1. The issue is taking the defendant's argument that there was no charge as to that conduct once she went to the couch. That wasn't the closing argument, and I imagine that since there was no objection to the instruction, that the issue would be whether that would be a substantial risk of a miscarriage of justice in the nature of the unobjected to jury instructions. That's the question, not the answer.
Well, I mean, first of all, I disagree that the general language used by the prosecutor absolutely could capture the subsequent conduct after the initial seizure of the phone, i.e. the grabbing the arms, the physical intimidation that kept her on the couch and away from the door despite her stated intention to get out of there and make the call, and the fact that she eventually did manage to get out and then immediately made the 911 call. So I disagree, first of all, as an initial matter, that a fair reading of the prosecutor's very brief 4 or 5 sentence argument did not encompass that behavior. At the same time, I don't think anything the prosecutor said or could have said would have changed the law of the case. The law of the case is the law as the judge provides it in the charge. The evidence of the case is what it is. It's what comes before the jury.
The jury have to be, so let's say that, does the jury have to be unanimous as to what the predicate is for the criminal conduct that's before the...
That's not an element of the offense. Yeah. There's no, maybe if we were dealing with C2, you'd have to show some kind of criminal act, because C2 references a violation of the law. C1 does not reference a violation of the law, and I agree with you. If we were dealing with C2, we'd have a host of problems that are not present here.
Cause physical injury or intimidation is element 1.
Well, intimidation we have, and I don't think there's any question. I mean, and the reality is Commonwealth versus Isle, Commonwealth versus Fletcher, 128 or not, this is exactly the same fact pattern. Commonwealth versus Isle, a full panel of the appeals court concluded this absolutely this taking the phone, this sense of captivity, all of it constitutes intimidation for the purposes of the statute. In terms of whether or not we're dealing with conduct in this case that constitutes intimidation, apart from the fact that it's nearly identical to the Commonwealth and Isle, how could it not be? I mean, he's physically preventing her. He's using indirect action, i.e. threatened physical assault. All of it's present here. If this is an intimidation, I can't imagine what is. The closed environment of the home, she can't get help. Indeed, she's trying to use the phone to get help. I mean, this is the essence of intimidation.
And counsel, does it matter that the jury did not convict the defendant of those crimes? Or the evidence is still in, is it not?
If conviction of those offenses were an element of the offense of intimidation, I would say it would make a huge difference. It's just not. Under C1, there's no requirement of identifying a specific crime. You have to show, obviously, the presence of intimidation. He clearly did things. He put her in fear, and she testified to that for the purpose of influencing her conduct. He was trying to prevent her from making the call.
Don't you have to have a separation between, even under C1, don't you have to have a separation between the act of intimidation and the act that's the basis of the criminal investigation? you're collapsing the two.
I don't think so.
Well,
I don't
that
think you
doesn't
do
make
at
any
all.
sense.
There has to be, well, there has to be reasonable foreseeability, and indeed many criminal, much of the common law and criminal statutes contemplate issues of foreseeability.
But,
There has to
but
be
let me
some-
just ask, I want to make sure I understand you. Is the act of intimidation can also be the criminal investigation?
It could be, absolutely.
But it could be? That doesn't make any sense then. So I'm reading the requirements as the jury were instructed. That the defendant directly or indirectly attempted to cause physical injury, I get that part, or intimidated her. That's an act, right?
Or a series of acts, as in this case.
Okay,
And
but
the series is
second,
very
that
important.
Ms. Ferraris was a witness or potential witness at any stage of a criminal investigation.
Right.
That's got to be separate, doesn't it, from the act of intimidation?
All that is required is that it be reasonably foreseeable that she is or will become a witness in any stage of a criminal proceeding.
In a case based on intimidation, or in a case based on something else?
Anything that's reasonably foreseeable at that time.
Any
And indeed,
case-
it's very often the case.
Any case say that?
Well, of course, Commonwealth versus Isle is exactly this case. I mean, I can cite that for any question you have about sufficiency here, because Commonwealth versus Isle was all about the question of legal
Wouldn't the
sufficiency.
fact that she said, I'm going to call the police, be significant in that regard, as opposed to I'm going to call my great aunt?
Absolutely. I mean, I get, yes, to answer your question, of course, yes. To answer Judge Caffer's question a little better than I did before, I mean, I think one of the things that you're focusing on here, and if it is a stumbling block for you, I'll say this.
I'm
If what
sure
you're-
there are all
if-
kinds
if-
of stumbling
If what you're
blocks.
concerned about is that this initial act of grabbing the phone is also the predicate for some future possible criminal proceeding as to which she might be a witness, I don't think you need to worry about that because there were enough subsequent criminal acts testified to in this case.
When I read your brief, you were trying to convert the screaming into an assault. I thought you were doing that because you felt you needed a predicate act, but now you're saying you don't really need a predicate act.
That's how you read it, Your Honor, then it was my fault for not being precise enough with my language, but absolutely not. What you need to have is proof of intimidation. The intimidation has to be directed at a person when that person has to reasonably, foreseeably be a potential witness in some future criminal proceeding that may or may not relate to the act of intimidation. It's often the case that a confederate of someone accused of a crime will intimidate a witness to encourage him or her not to testify in that proceeding, in which case they're totally unrelated. It certainly could be part of a transaction, and that was the Isle case.
The person doesn't need to be the same. The person who commits the predicate act doesn't need to be the same person doing the intimidation.
Absolutely
Usually
not.
it's the opposite.
Right, I agree.
But I'm just trying to understand whether you've collapsed the two and whether that's permissible or not. But I got to reread the case you're talking about.
Okay, good.
But don't you still need, for the foreseeability prong, even under your theory, wouldn't you still need there to be a crime?
Well, and there was a whole series of crimes here, and he was charged with a raft of offenses. The
Crime
fact that the
crime
jury acquitted him.
at the time of the taking of the phone, which is
But
what the jury was instructed.
Again, that has somehow become a myth that is pervading this case.
That's what the
that
jury,
everything
that's what the
relies-
judge, page 156, told the jury was the offense.
No, he didn't say that. What he said was, and I'll read the charge again.
Go back to page
was that he engaged-
156.
He prevented her from calling the police. And the preventing her from calling the police consisted in part of taking the phone, but it also consisted of him subsequently confining her on the couch, grabbing her arms when she attempted to leave, blocking her path when she attempted to leave to make the call. All of those things constitute preventing her from making the 911 call. It wasn't simply the act of taking the phone. That is by no means the only act of intimidation present here. In fact, it is among the most minor of the acts of intimidation, I would argue. The physical conduct where he's grabbing her arms, physically restraining her, preventing her from leaving, those are far more egregious examples of intimidation, in my view. But this idea of freezing the scene here at the moment the phone is seized and say, now, is that legally sufficient to justify the intimidation charge? That's a myth that's been injected into the case by my brother. It's a fair strategy, to be sure.
I don't know if he injected it or your trial prosecutor injected it. But
Either way. But in any event, the reality is there was a 45-minute stream of conduct here, which included countless additional acts of intimidation. all of which likely also constituted or reasonably could constitute offenses and would be foreseeably the predicate for a future criminal proceeding. So all of them would justify, any one of them would justify
All right,
application of
so
the statute.
I understand you're saying it doesn't matter in this case because of what happened after she went to the coach. Okay,
Exactly.
fine. But let's go back to the question I think that's being asked. I know you say it doesn't matter. The cause of physical injury or intimidation, the element one, there has to be some sort of crime that has been committed because the subsection 1 says any stage of a criminal investigation. That means that there's some crime.
That's where we disagree, Your Honor. What I'm suggesting with respect to lowercase 1 is when they talk about a witness or potential witness at any stage of a criminal investigation, and it's not set off by commas, so read it carefully. I encourage you to read it carefully. That's simply further describing the kind of witness they are talking about, a person who is a witness or a potential witness, i.e. a person who is reasonably, foreseeably going to be a witness in some criminal proceeding of some type. And indeed, every one of the 1, 2, 3, 4, 5, all describe groups of individuals covered by the statute. None of them contain language which in any way has ever been read to modify C in the preceding paragraph. So that is simply a descriptor of the kind of people that are involved. It is not injecting a requirement or an element into this offense of finding some predicate offense to peg it to. Now, I agree with you, number 2, right below it, that speaks about a criminal statute or violation. Absolutely, we would have to, it would be incumbent on us to establish, and the jury would need to find some violation of a criminal statute. But that's not what we're dealing with here. The judge didn't charge on that prong, and there's no reason to address it.
But how can there foreseeably be a criminal investigation unless there's a crime?
I agree with you. There has to be some criminal conduct, but you don't have to identify the crime in the same way you would have to. Number 2 clearly cries
I
out.
lost you, but doesn't the foreseeability of a criminal investigation require that there has to be evidence that there was a crime which would warrant a criminal
Absolutely.
investigation?
But
So you're back to
Justice
where
Kafka,
Justice Lowy said you needed to be, was that there has to be a crime.
but the
before
crime doesn't
act-
have to be committed by the person causing the intimidation. The predicate crime.
Well, I understand that, but that's not at issue here.
Well, I
There's
thought
no-
that was
there's
what Judge
nobody
Loy
else.
was asking. The idea that the
No, but there has to-
conduct here has to be.
Well, I mean, I understand that there could be, you could have a boyfriend protecting a girlfriend, but that's not, here there's only one person who's at issue, and he's both allegedly the perpetrator of the crime and the perpetrator of the intimidation. But you agree there has to be a crime before
Absolutely.
the intimidation for the person being intimidated to be somebody who is foreseeably going to be a witness in a criminal investigation.
I will say yes to that. Having said that, the statute speaks of a person who is potentially a witness in a criminal proceeding of some type. Whether that has to constitute a crime, could I foresee a case that didn't constitute a crime that was nonetheless part of a criminal proceeding? Because they talk about all kinds of ancillary proceedings in the case law relating to this statute, sentencing procedures, et cetera. But to answer your question specific to this case, yes, I'll say yes, and I will absolutely say that this case is, you pick the crime. I mean, there are any number of offenses for which it was reasonably foreseeable at that time that this person might become a witness at a criminal proceeding. He had assaulted her, he had grabbed her, he had taken
I'm
her
getting
phone, he had
confused,
confined her.
though. Okay, but the intimidation, what is the rule? Doesn't it have to happen before the phone is grabbed? Or is that a whole, all the briefs have been about the phone, but it's really not? The case is being transformed from what was briefed, so now I'm getting lost. So is there any importance to the phone at all?
The importance of the phone is that it sets the tone for all that happens later. I think it's important to interpret all of his physical acts of
So the
intimidation as relating
so
to
the
his desire to
intimidation,
prevent her from using the phone.
I'm confused. So the intimidation happens before the crime? That's basically what you're saying.
Absolutely not, Your Honor. And I
Okay, then
apologize if
give
I took
me
it that way.
explain to me how the jury convicts on intimidation. Give me the predicate act and the act of intimidation. Just simplify it for me for a second from the
So
Commonwealth's
the acts of
perspective.
intimidation are all of the things that he did including restraining her physically, the indirect acts of restraint that he did through his conduct and his implied acts of assaultive behavior, all of that transpired during the 45 minutes. Multiple occasions in which he's trying to leave the apartment and he's preventing her from leaving, as I say, physically grabbing her. All of those things are acts of intimidation. So there are many
Okay, I
acts
get
of
the act. Now,
intimidation.
what is the underlying crime that he's intimidating her
Now,
about?
as a result of the conduct in which he himself has engaged, i.e. keeping her in the apartment, grabbing her, all the things that he has done, putting her in fear, all of those things could reasonably result in her being a witness in some future criminal proceeding.
Now you're reversing what you just said to the Chief Justice. So I'm trying to, we asked you whether you have to have a predicate act separate from the intimidation. You said yes, but now you're saying no. What is it?
The Chief Justice was asking me whether it was necessary to have a separation between those two. Absolutely not. In this case, we have acts of intimidation which give rise to the potential for a future criminal proceeding. Are there cases where the opposite could be true, where the intimidation is unrelated to the predicate act that might potentially give rise to a future criminal proceeding? Absolutely.
So just let me summarize, because you're saying then that the acts of intimidation alone can be the basis for the conviction of intimidation.
The acts of intimidation in this case, all of them, together are what make it reasonably foreseeable that this person, this victim, will be a witness potentially in a future criminal proceeding.
In a case on intimidation. Okay.
There were a range of criminal acts there. He was charged with a range of criminal acts ranging from kidnapping and easily could have been charged with the assaultive behavior as well. But it was reasonably foreseeable at the time that he prevented her from making that 911 call that she would be a witness in a future criminal proceeding.
Okay, thank you.
Thank you very much.